Welcome or welcome back, everybody, to the Beau Knows Real Estate Podcast. I am super pumped about this episode today. I have Scott Drucker, the CEO of Arizona Realtors, on the show today. First of all, my name is Beau Bullard. I'm with Pioneer Title Agency here in the state of Arizona. And like I said, today is going to be phenomenal information, and I'm really excited to share with you all today. So, Scott Drucker, thanks a lot for being here. I really appreciate you taking the time.
My pleasure. Happy to do it.
So before we get into it, I know that a lot of people are excited for this one. We're going to be talking about the lawsuits. We're going to be talking about a bunch of things within real estate. Before we do that, go ahead and just introduce yourself for a few minutes.
Yeah. Well, thanks, Will. As you mentioned, I'm the current CEO of the Arizona Association of Realtors. We're the largest trade association in the state of Arizona. We've got about 55,000 members, so that certainly keeps me busy. We're also the largest political action committee in the state.
Awesome.
Prior to becoming CEO, I was the general counsel for a little over a decade. So I am a licensed Arizona attorney. And prior to joining AAR, I was actually a partner in a law firm practicing real estate. And a large part of my practice was insurance defense, the defense of real estate agents and brokers all across the state of Arizona.
Awesome. Very cool. So actually tagging along with that, I know that I had somebody ask a question on Facebook and they were curious, how did you get in this line of work? Like what made you want to go into this?
Sure. So, in law school, I did actually really enjoy my real estate class, and moving to Arizona, I wasn't practicing real estate when I initially graduated from law school. But when I moved to Arizona, I met another attorney who was a graduate of the same law school I went to, and he had a law firm that did real estate work. And he offered me a position, and I really enjoyed it from day one. Not just the attorneys I was working with, but the nature of real estate. I don't have to tell you, we've got a fascinating real estate market here in Arizona, right? It's up, it's down, it's right. Really interesting, and it keeps me busy. So it's something that I do enjoy. And I'm happy to be practicing real estate for sure.
Awesome. Yeah, I know. I've been talking to a lot of people about today's episode and my conversation with you, and so many people have been just so impressed with you. They've mentioned that you're just a wealth of information, and I think anybody that knows you can attest to that. So, I'm going to jump right into the main topic that everybody wants to know about, and that is these lawsuits going down over at NAR. And how these things are going to play out in the long run for the real estate industry. So if you don't mind, start from the beginning. Let's talk about the class action lawsuit. I know that you and I had talked about it a little bit before at a meeting I attended and you were at. And correct me if I'm wrong, but just for some context, it's a class action lawsuit. The plaintiffs, as you described it, are sellers that have sold a house using an agent that received commission in part or in full in some way.
Yeah, so there's two class action lawsuits, right? There's the Stitzer case and the Merle case. The Merle case is in the Northern District of Illinois, and the Stitzer case is in Missouri. And the Stitzer case is the one that's actually set to go to trial in really just a week from now. So we will know a lot more once that trial starts.
Right.
But yeah, so they are class actions, which means it's a group of plaintiffs who have similarly situated claims. And in these cases, as you mentioned, the class of plaintiffs are individuals who sold a property using one of the subject multiple listing services where the listing side paid a commission in full or in part to the buyer side.
Okay. So kind of walk us through what's happening, what's expected to happen. I know that there have been a couple of companies who have offered to settle with the court. I know, was it EXP? Was it Remax? I think it was Remax. Was it $53 million?
Yeah, so Remax settled, I think it was $55 million, and then a company by the name of Anywhere, which used to be Realty, settled for, I think it was $83.5 million. So that leaves, as defendants in these cases, the National Association of Realtors and two other corporate defendants, which are large brokerages. So those are the remaining defendants. And look, a lot can happen in a week. So it's certainly possible that settlements can be reached by any one of the remaining three defendants in these cases prior to trial.
Right.
As you know, it seems like a closer a deadline gets, right, the more things heat up and the more intense negotiations become. So we
Right.
really don't know what will happen in the next week, but I certainly think that this shows by the plaintiffs a willingness to settle. But it certainly, my guess is that it would be difficult for NAR to settle the claims just based on the nature of the damages that from a monetary perspective, that the
Right.
that the plaintiffs are seeking, and also, you know, the National Association of Realtors strongly believes in their MLS procedures and policies. That I personally think, as does NAR, that the MLS is pro-competitive, it's pro-consumer, it's efficient, and maybe the best thing about it is it's transparent. So it's
Right.
created a system, in my mind, that yes, it does help buyers, but it also, the way it works with the compensation is it helps the sellers as well, right? Because what do sellers want to do? They want to sell their home. Well, then you need a system that enables buyers to be able to purchase the home. And I think
Right.
that's really the reason behind these MLS procedures and policies that we live with every day.
So what was the main reason for the lawsuit in the first place? What was
the allegations, essentially? So, right. So the plaintiffs allege that, hey, there's this conspiracy, right? That these defendants got together and either created, abide by, enforce MLS policies. And that these MLS policies, they allege, financially harm the sellers, right? Because you have the sellers that are saying, well, wait a minute,
Right.
I pay my agent. Why am I also compensating the buyer's agent, right? The seller is saying the buyer's agent doesn't represent me.
Right.
Transaction. They don't act in my best interest. In fact, they're the party that's negotiating against me. So
Right.
the sellers claim that because compensation is required to be offered in the multiple listing service, that they have been financially harmed by a system that they deem unfair.
Okay. I know a lot of people, because that's kind of the main gist that people have been getting. Have you been hearing a lot of, this is the way things have been going forever, why are we wanting to change it now? And then what's the argument against that?
So, I mean, look, there are some newer policies, right? I mean, clear cooperation is a newer policy. It's been around for a couple of years now, but
Right.
it hasn't been in existence forever. But there is a reason why this system has been around for so long, and I think
Right.
it's successful. It's successful for all the parties involved, right?
Right.
Put yourself in the shoes of a buyer, right? We know buying a home is expensive. It's hard to come up with money to put down. It's really hard to come up with if you want to put 20% down. Now
Right.
imagine you're a buyer and you're in a position where at close of escrow, you not only have to put the money down, but you have to pay your agent's commission in cash at close of escrow, right? That would be incredibly difficult for buyers to do, and act as a deterrent to their ability to buy a home. And who does that hurt? Well, it hurts the sellers. And that's what
Right.
we're hoping the jury will really understand when these cases go to trial.
So is that the direction that you see going? Because the conversation out in the streets, if you will, is people discussing the possible outcomes of what's going to happen. And number one is okay, it goes in one direction, and now buyers are going to have to pay for their own representation in an agent. And like you're saying, it's going to be in a lot of cases impossible for that to be the case. So a lot of buyers will be eliminated from the market. And then it's going to give sellers less options. So do you see it going in that direction of where buyers will then have to pay for their own agents?
Look, I think it's certainly possible, and we're already seeing instances where the multiple listing services are no longer requiring mandatory offers of compensation to the buyer's agent. But the question is, what are sellers actually going to do, right? And I would say that this system, if they want to sell their property, incentivizes sellers to offer compensation to the buyer's agent because, again, sellers want to sell their home. But if you're asking, could the nature of buyer representation change? Yeah, the answer is yes, right? Because you have these plaintiffs who are looking at this situation in a very narrow lens. They're not looking as to what's best for the real estate industry as a whole.
Right.
So when they look at it, their thought is, well, if buyers, there's nothing that requires buyers to have representation. If buyers can't afford representation, they shouldn't be represented in a transaction. But That's not good for buyers, and it's not good for sellers either.
Right.
And so I think that the plaintiffs, again, are looking at this through a very narrow lens without fully understanding the negative consequences it'll have across the board, because we know that these commissions cannot be wrapped into the loan, right? So again, that means the buyer would have to come up with the money. Now, are there other ways, if this takes place, that the market could adjust? Yeah, and I think that remains to be seen. But certainly a concern is how these lawsuits could affect the nature of the buyer representation.
So you had said that the buyer's agent's commission can't be wrapped into the loan. That's been something that a lot of people have been discussing as a possible outcome. Explain why it can't be wrapped into the loan.
Sure. So let's say we know that when a lender lends money, they need to be secured, right? They need to make sure that if the buyer defaults, that they have the ability to foreclose on the property and satisfy the loan that's been issued.
Right.
But now, if you have the lender lending not just on the value of the home, but in addition to that, the commission, where the lender would be concerned is, am I adequately secured, right? Because now, if I foreclose, am I going to get the money that would cover what the full amount of that I lent to the buyer? Because again, you're now lending not just on the value of the property, but also on the commission. And you would potentially leave lenders in some situations not fully secured. And that's something from a business perspective, if you're a lender, that doesn't work with your business model.
Right. Okay. Yep. No, that makes sense. That clears it up. We were chatting a little bit before we started this podcast about the fact that I asked the audience, if you will, to ask you questions about the things that they're thinking about. And so I kind of want to jump into some of these questions. We had talked about the MLS, and it seems like you enjoy the MLS. You think it benefits everybody, right? And so one of the questions was about the MLS. What is your stance on a statewide MLS here in Arizona?
So that really is up to the members in the local associations. We at the Arizona Association of Realtors don't have a position on whether a statewide MLS would or would not be beneficial. That's something, the locals have made the decision that currently, from their perspective, these individual multiple listing services best suit their needs. And if that's the case, I understand that, and that's certainly a decision that I respect. Right. I can't put myself in their shoes and make a decision as to what's best for them. They have to make that decision for themselves. And if they've made a decision that they're better off with independent multiple listing services, well, then that's what we'll have. But yes, I do agree with you, about the benefits of the multiple listing service. And one of the things that I think we talked about a little bit was, one of the great things about the multiple listing service is it exposes a property to the widest possible pool of buyers, right? Because sellers, the theory, right? The greater the number of people that view the property, the more people that are interested, the more people that are interested, the more offers, and the more offers would hopefully result in a higher sales price, which again benefits the sellers, these plaintiffs. So we're hopeful that the jury will understand how the multiple listing service in many different ways in these local marketplaces benefits the sellers who are the plaintiffs in the lawsuits.
Yeah. No, that makes a lot of sense. That the MLS conversation is interesting. It seems like each person you talk to has a little bit of a different opinion on it, and so we'll see what happens. This here is an interesting question. So, do you foresee listing agent commissions going away in the near future? There are companies popping up advertising no commission fees. Is the reality that a traditional agent will be a thing of the past?
I don't think so. When you look at surveys that have been done all across the board, you see repeatedly that buyers and sellers want representation, right? This is the largest transaction of their life. Think how much money is at stake. They want representation, and in some instances, like everywhere, you get what you pay for, right? And if you want an experienced agent at your side representing you, looking out for your interests, there's a price, right? They are earning a living; they're providing a very beneficial service. So no, I don't see listing agents going away. And again, study after study shows that buyers and sellers want representation. So I feel personally confident that representation will remain in place for sure.
Right. Okay, so I was just thinking about something. I'm going to step away from the questions here because the CEO of Zillow, I believe it was, made a statement saying that based upon the outcome of these lawsuits, we may see over 200,000 buyers agents leave the market. What are your thoughts on that?
I think that that's a strong statement and not one that I would agree with. But look, I don't have a crystal ball.
Right.
The CEO of Zillow, so we don't know what would happen. But again, operating under the assumption that buyers and sellers want representation, you're going to have buyer representation. It's just that the market may have to adjust as to compensation. But if you've got sellers that want to sell their property, and in order to help them do that, they deem it beneficial to pay for a buyer's, the commission for a buyer's agent, then the model will remain in place. So I think that that's a very strong statement and not one that I would agree with. I think it's too strong a statement.
It almost seems like a scare tactic, really. It's like, I mean, when you hear that, everybody's like, oh my gosh, what's going to happen? Like, and so especially in the real estate industry, I mean, that's a huge number. And, I agree with you. I do think it's a very strong statement, but a lot of people look at that and they're like, okay, the CEO of Zillow is saying that it must be happening. And so it's kind of a scary thing. Okay. This one's also a good one. So, how do you propose various associations, MLSs, handle the brokerages that wish to not be members of NAR? What does he see as possible issues if we update our policies to allow non-realtor members join the association and MLS?
So a lot of the MLSs already have policies in place that allow for non-realtors to be participants in the multiple listing service.
Okay.
Here in the Valley, we have one of the largest multiple listing services.
Right.
And it's the largest in the state, which is ARMLS.
Right.
We have policies that allow non-realtors to become participants in the multiple listing service. So that already exists in this market and in other markets across the country. Now, we've learned as part of these settlements that some of these brokerages have come out and said we will no longer require our agents and brokers to be members of the National Association of Realtors. And I would tell you that I don't think anybody should be required to be a realtor.
Right.
I think it's incumbent upon us to offer benefits and services that make these agents decide, I want to become a realtor, right? That for example, the dues to join the Arizona Association of Realtors, it's $175 a year. We recently dropped it by $15. I think we're the only state association in the country that in the recent years has actually lowered our state dues. But we do it because we're sensitive to the members, and we realize we don't want any financial barriers to becoming realtors. But again, it's our job to show our value, right? And to show that you're getting a whole lot more for $175 than you would if you were not members, right?
Right.
Access to transaction desk, access to the forms. I mean, the lobbying we do on behalf of our members, the educational offerings, transaction desk, the tech helpline, the legal hotline. I mean, you think about that. I mean, $175, you've got a question and you want to call an attorney and you talk to that attorney for a half hour, there's your $175 right there. And we're giving you access to the legal hotline, for an unlimited number of calls throughout the entirety of the year.
That's cool.
Right. And so I think that the $175 is money well spent. But again, it's our job to convey our value and to allow agents to make the decision. Hey, I think that is money well spent, and I will pay the $175 because I get a lot for the money that I pay.
Right. No, absolutely. Okay, so another thing that has come up quite a bit is dual agency. Talk to us a little bit about dual agency. Do you think that's going to become a more common thing, a less common thing? What are your thoughts?
Yeah, I mean, look, it has the potential to become more common if you have sellers that decide they're not going to necessarily pay the entire commission for a separate buyer's agent.
Right.
But there's also buyers and sellers out there that fundamentally prefer not to be participants in dual agency, right? They want their agent solely looking out for their best interests.
Right.
Dual agency is a form of limited representation. And so they're not receiving, the full benefits that a single agent in a transaction, that's representing just one party may be able to provide. Dual agency is legal in Arizona. I will tell you that if you're acting in the capacity of a dual agent, you've got to be very careful and pay close attention to all of the rules and laws that go along with that. But it's done on a daily basis. It's done well, and it's done to the satisfaction of buyers and sellers. So I certainly don't see dual agency going away. Could it increase? Yes, but I still think you've got buyers and sellers that are anxious to have an agent that's just representing them in the transaction.
So are there any key points that agents should keep in the back of their mind, and maybe things that agents don't think about all the time, especially thinking about dual agency going forward? Are there things that you would suggest to everybody, like pay attention to this one or two things?
I think one of the critical things that agents need to do, and we can all probably do a better job of this, is let's say you're an agent that's representing a seller. You've got to make sure that seller understands that commissions are negotiable. You have to have that conversation with them, and you have to have it in depth, right? You have to, first of all, the compensation is negotiable in regard to their own agent, right? I mean, the listing agent may say, this is what I charge, but the seller has the ability to say, yes, I'll pay that. No, I won't pay that. Or how about I pay this? The agent doesn't have to agree, but they hopefully will reach an agreement. Then, that same seller also can make the decision as to how much they want to offer the buyer's agent.
Right.
These are conversations that agents need to have with their clients so that they really have an understanding that commissions are negotiable, and they're not just being told what has to be paid, but that they have say and decision throughout that process.
Right. Do you see that there isn't as much of that, maybe transparency among the industry, that there needs to be more? What are your thoughts?
Yeah, I think it depends on the individual agent, and I'm not out there, so I can't tell you what all agents do or do not do. But I think, again, just across the board, we can probably do a better job of having that conversation, with our sellers. NAR is also encouraging the use of buyer representation agreements. There are some states that have made buyer representation agreements a legal requirement. We don't have that requirement currently in Arizona, but is it possible that in the future we could? Yes. But one of the, besides the fact that buyer representation agreements do a very good job documenting the services to be provided, they also document the compensation, and the plaintiffs' attorneys in these lawsuits would have us believe, well, what do you mean? The compensation always comes from the seller side.
Right.
Well, a buyer representation agreement could show otherwise. And so I do think we'll probably see an increase in the use of buyer representation agreements, and that's certainly something that NAR is encouraging members to do.
Right. Okay. Yeah. No, that makes sense. Okay. So this question, let's see. If sellers offer a zero buyer broker fee, can the buyers use seller concessions to pay for their buyer broker fees?
They can. It's all subject to negotiations. So if that's the route that they want to take, they can do that. Verbiage in the Arizona Realtors residential purchase contract is very broad in that regard. So there would be nothing that would prohibit it within the definition of seller concessions.
Right. So kind of going back to the national lawsuits that everybody's talking about, walk us through some of, and I know you've done this a little bit already, but walk us through some of the more possible outcomes that you see, and kind of how that may reflect on the real estate industry going forward.
Sure. There is such a wide spectrum of potential outcomes, and I think if you ask any trial attorney, and including me, they've won cases that maybe they thought they were going to lose, and they've lost cases they thought that they were going to win. So I will tell you that whatever the outcome is, there's going to be an appeal, and appeals will likely stretch on for years. But the plaintiffs are asking, first, the desired outcome is a judgment in favor of the defendants in full. right?
Right.
That's the desired outcome, and what we're all very hopeful is we're going to accomplish.
Right.
There's also outcomes that could involve, if the plaintiffs prevail, monetary
Right.
damages, and those could run the gamut. We certainly
Right.
don't know, is it going to be a minimal amount? Is it going to be a substantial amount?
Right.
Plaintiffs are also seeking an injunction in regard to MLS policies.
Okay.
Maybe there could be an outcome where if you're publicly marketing a property for sale, you're no
Right.
longer required to put it in the multiple listing service. There
Okay.
could also be an outcome where they would agree to policies, or policies would be imposed on them, where there is no longer mandatory offer of compensation from the selling side to the buying side. So I can see the MLS changing in that regard if there is a judgment in favor of the plaintiffs. And then, of
Right.
course, there's the possibility of monetary damages. And we just have no idea what those would look like, or what a jury would think is an appropriate amount in a case of this nature.
Yeah, that doesn't seem like something that would happen. It seems like, I mean, monetary damages, that seems like a kind of a reach, in my opinion. I'm just sitting.
So yeah, so you have these sellers that are saying we were financially harmed because we had to pay the buyer's agent. But what they don't mention is that after they sold, they then became buyers and benefited from that same system on their
Right.
on their very next transaction. So really,
Right.
were they financially harmed? They benefited when they were on the other side of that transaction. So I think there's a strong argument to say no. So
Right.
I hope you're right, Beau, that even if there is a ruling for the plaintiffs, that there's no monetary damages imposed.
Yeah, I mean, it just, in my opinion, that seems like, it's a bit of a reach, but I mean, it's gotten pretty big. I mean, everybody's talking about it, and it's scaring everybody. So it's like,
yeah, and
it's going to happen.
The plaintiffs are seeking billions with a B, billions of dollars in damages. So there's certainly a big number floating out there.
Yeah,
that doesn't mean that they're going to, even if they prevail, get a judgment anywhere near the amount that they're seeking. And again, the hope is that there'll be a complete judgment in favor of the defendant. So monetary damages would be a non-issue.
yeah. So how many plaintiffs are there in this class action lawsuit?
Yeah, I don't know the exact number, but what's interesting with these class actions is they're what's called an opt-out as opposed to an opt-in. So in other words,
Right.
some class actions are opt-in, where you got to actually pick up the phone, call the plaintiff's attorneys, and say, I want to be a party to this lawsuit. Well, unfortunately, that's not how these class action lawsuits are working. These are opt-outs, which means, because again, you're automatically a party if you sold a property using one of these multiple listing services and a commission is paid in part or in full to the buyer's side. So in order to remove yourself from the class action, you've got to, take proactive steps to contact the plaintiff's attorneys or the court and remove yourself. And I just don't think a lot of, individuals are doing that, even if they're, and most of them probably aren't even aware that such a lawsuit exists.
Yeah, I mean, there's a lot of people just in the real estate industry that don't know what's going on. So just regular consumers, I mean, they definitely don't know. So how is it determined whether it's an opt-in or now opt-out?
It's a good question, Beau, and I don't actually know the answer to that. I'm not sure in this case how the court made that determination as part of their class action certification. I don't know.
Yeah.
Question. I'm sorry, I don't have a better answer for you on that one.
No, I don't know. And I just was like, I don't understand how is it the number of plaintiffs that they decide, you know what, okay, there's so many that we're just going to make it, you have to opt out of this. I mean,
the part that I've been focusing on is, the class action certification itself and the decision that the court made and how that's been perceived by the industry, because I think that there has been some misconceptions about class action certification. And what I mean by that is, when a court determines that they're going to certify a class, they're doing it for the purposes of judicial efficiency, so that they're hearing one large lawsuit as opposed to thousands of smaller lawsuits, where each of these sellers has to bring individual claims. What they're not doing is they are not making any sort of ruling on the merits when they decide to certify a class. And so, in other words, the court isn't looking and saying to the plaintiffs, hey, you've got really strong claims here, or I think you've got a good possibility of success in this lawsuit. That's not what's happening with class certification. So But I do think, and I've heard this, when I've been out speaking with members, that there's a misconception that they believe that because the class was certified, somehow that reflects positively on the nature of plaintiffs' claims, where it does not.
Gotcha. Okay. No, that makes sense. Okay, so this is a little bit of a different topic here, but is it a rule to refer 3 different lenders or any type of suggested practices to consumers?
Right.
So, for example, I mean, I think but just for the audience, is it a rule for maybe a realtor to refer 3 different lenders, 3 different title companies, and then vice versa? Is it a rule for title companies to refer 3 different realtors or 3 different lenders? Thoughts?
Right. There is no such rule. There is no rule in law that requires it. There's no statute, anything of that sort. Where this stems from, Beau, is there is a claim out there that's it's called negligent referral. It's an incredibly difficult claim to prevail on because you essentially, if you're a plaintiff, you have to prove that the person that referred you, was negligent in their referral, that they knew that who they were referring you to was somehow not competent or not able to provide the services. So it's a really hard claim to prevail on. But just to avoid that possibility, yes, it is often recommended that whenever you're recommending a third-party professional, whether it's a title company, whether it's a home inspector or a company, whatever it is, that you provide multiple names so that the buyer in some of these cases would be able to do their due diligence, their research, and make a decision as to what party, title company, home inspector, which one best serves their interests, which one best meets their needs, so they can make the decision for themselves.
Right. Okay. No, thank you for answering that. Similar topic here. There's been a lot of chit chat going on around joint venture companies and different things, and I don't want to get into the weeds about it. What I want to do is I want you to let us all know how we can all protect ourselves, whether we're in the title company, whether we're a realtor, lender. What is the best practices for us to make sure that we're always playing by the rules, things to avoid, things to go and do. What are your overall thoughts?
It's actually, I know it's a fairly complicated topic, but the answer I think is fairly straightforward, which is ensure RESPA compliance, right? You've got to make sure that you're complying by RESPA rules. And so you said one of the things you shouldn't do, kickbacks, right? Direct kickbacks is an absolute no. And then you can't provide benefits or services that exceed, the true value of those. So in other words, let's say a title company is going to place an advertisement in, a national magazine or an Arizona magazine, and they're going to represent themselves and they're going to represent an agent in there. Well, if the page takes up 50% of it's for the agent and 50% of it's for the title company, the agent should be paying for that 50%, right? It shouldn't be the title company paying 100% of it, and it shouldn't be the title company paying 95% of it. Everybody's got to make sure that, they're carrying their own weight when it comes to those sorts of services. And the other big thing is the affiliated business disclosures, right? Making sure that those are properly signed, that disclosures of compensation are being made. Yes, there's been a lot of talk around joint ventures, and I know that it has been a topic of conversation, probably maybe you had with Commissioner Nicholson. I know it's been a topic of conversations that I've had with Commissioner Nicholson. She is out there looking to make sure that the public is safe, that these title companies, because there is such a thing as sham title companies, that really, you're smiling, Beau, and maybe you could speak to some of these better than I can, but they're not funded. They're not really providing services across the board that they should be.
Right.
She's looking to make sure that things are RESPA compliant, that proper disclosures are being made, and that they're in the file. And I applaud her for doing that, because if agents are going to enter into joint ventures, they need to make sure that they are done properly. And if they have concerns about that, they should talk to their broker, or they should retain counsel to make sure that everything they're doing complies with federal law.
Right. One of the things that Commissioner Nicholson was talking to me about was, she's talked about this a lot to a bunch of different groups, but one of the things that she had said was, the brokerages attorneys, may say, oh yeah, we're all good with something. And she said, well, also get your own legal opinion on the thing that you're dealing with, because just because one attorney says something doesn't mean that it could be right, or whatever the case may be. And so she made a very good point there. And I think, my job is to obviously, with this podcast, is try to educate people as much as I can. That's why I feel so honored to have you on, Scott, because you have so much knowledge to share with everybody. And so the reason I bring these things up, like the joint ventures and the affiliated business agreements and all these different things, is because due to my conversations with Commissioner Nicholson, there are some horror stories, is what I call them. Yeah. And I'm trying my best to help every realtor in Arizona try to protect themselves. And you don't even have to be using Pioneer Title. Just make sure that you are covering your own tail, because Commissioner Nicholson, she's out there and she's keeping her eyes on people. So
yeah, and look, that's her job, right? Her job is to protect the public. And if there are instances where RESPA is not being followed, or the proper disclosures aren't being made, that can hurt the public. And so she's doing her job. That's what she's been hired to do. But I will say, just inherently, there's nothing negative about joint ventures, right? If you're an agent and recommending a title company with whom you have a joint venture, that disclosure form that the party's going to sign lets them know that, hey, you can still shop. You're not obligated to use any title company. In fact, you're in any particular title company. In fact, we encourage you to shop. And there's nothing that says that just because there's a joint venture that title company's fees are more than would otherwise be the case. So the public is not being hurt by properly run RESPA compliant joint ventures.
Right. Yeah.
And I think that's an important point.
It is an important point, and I'm glad that you mentioned it, because I agree with you. I know people who have joint venture agreements, and they're great. But like I said, the horror stories that I have heard from Commissioner Nicholson and other stories that I've heard personally, it's like, let's just all make sure that we're protecting ourselves and work together to protect ourselves and do the best service for our consumers.
And so and here's the thing I would add to that. I don't care what the industry is, you're going to have some bad actors, right? And no matter what the industry is, they're out there. And so, our industry is susceptible to those bad actors the same as any other industry is.
Right.
I'm very pleased with the fact that I think 99, +% of our members are doing it the right way. Yeah, of course. Are there some that, are bad actors? I'm sure that there are some out there, because inevitably, as I said, every industry is susceptible to them.
Oh, absolutely. And Commissioner Nicholson said it best. She was describing how much respect that she has for real estate licensees in Arizona. They're hardworking Arizonan folks that are always just trying to do good. And like you said, it's not just real estate. Every single industry, whether it's law enforcement, whether it's teachers, whether it's whatever, there's going to be bad apples. So, that's a perfect way to wrap this up. Scott, again, I really appreciate this. Thank you very much for taking your time out of your day to join me. And so anybody who is watching or listening to this, please reach out to me, reach out to Scott. Let us know what you think. If you have additional questions, I'd love for you to reach out to one of us, and I'll try to direct you in any which way that you need to get those questions answered. And then Scott, I know, is always happy to help as well.
Yeah, and Beau, I'll just let you know, our website for our association is aaronline.com. It has all of my contact information on there, plus a wealth of resources. So you can certainly use that to get my contact information, along with tons of other information of the benefits and services that our association offers to our members.
Awesome. Yeah, I'll make sure that I link that up so people can go right to it if they have any other questions. And Scott, thank you again. I really appreciate it. And maybe we'll do this again in a couple of months once the trials and everything are over, and kind of discuss the outcomes. That'd be fun.
Sounds good, Beau. I appreciate it. Thank you so much.
Awesome. All right. Thank you, Scott. Thank you, everybody who tuned in. Stay tuned for the next one.